Thank you for spending time with me. It is important to note that the information provided here is not legal advice. If you've been injured due to the actions or inactions of another person, I encourage you to seek the legal advice of a licensed attorney or contact our office at 832-702-2424. With that said, let's discuss Dram Shop litigation, how it evolved, and more specifically, what are the rules in Texas and Oklahoma. The term dram is first noted as being used in the 1500s as a small liquid measurement about 3/4 of a teaspoon or 1/8 of a fluid ounce. A dram shop refers to establishments like bars, pubs, taverns, or inns that dispense alcohol in drams. Before Dram Shop Acts, individuals harmed by intoxicated persons, often referred to as third parties, could solely seek compensation from the intoxicated individuals directly that caused them injury. There was a prevailing norm of non-liability for businesses or hosts involved in the sale or dispensing of alcohol. In fact, a common law rule was that a provider of alcohol is not civilly liable for injuries caused by the acts of an intoxicated person. A standard dram shop law states that if a business or host serves alcohol to someone who's clearly intoxicated and that intoxicated person hurts third parties, a legal claim against the business or host that served alcohol to the intoxicated person is permissible. In certain jurisdictions, an intoxicated person may pursue a claim against a business or host that served them alcohol for injuries they sustained through their own actions. So where did this legal concept come from? Well, in the early 1800s, the temperance movement emerged in the United States, which advocated initially for moderate alcohol consumption and later complete abstinence from alcohol. This movement particularly found a strong foothold in the state of Maine, where the Maine Temperance Society played a pivotal role, and in 1846, Maine became the first state to prohibit the production and sale of alcohol, followed by the enactment of the first Dram Shop Act in 1847. Maine was also the first state to ban alcohol possession in 1851. It should be noted that during the time when the first Dram Shop Act was introduced, James Polk held the presidency and the American Civil War had not yet started. The inception of the first commercial automobile sale wouldn't occur until the late 1890s. Thus, the primary purpose of these early Dram Shop Acts were to tackle injuries or harms generally caused by individuals under the influence of alcohol, rather than intoxicated driving, which wasn't a thing at the time. The temperance movement continued to expand nationwide throughout the late 1800s and into the early 1900s, advocating for a nationwide ban on alcohol sales and imports, ultimately leading to the 18th Amendment to the United States Constitution in 1919, which began Prohibition. However, this era of Prohibition came to an end in 1933 with the ratification of the 21st Amendment to the United States Constitution, which repealed the 18th Amendment, thus ending Prohibition. Notably, the United States lacks a federal Dram Shop Act. Instead, each state is responsible for formulating and enforcing its own dram shop laws, that is, if they even have any, which results in a significant variation between states. Many Dram Shop Acts were passed by states prior to Prohibition, and it did take a substantial amount of time for Dram Shop legislation to gain widespread acceptance. 43 states have Dram Shop Acts. The following states do not have Dram Shop Acts at all: Delaware, Kansas, Maryland, Nevada, South Dakota, Virginia, and Louisiana. Louisiana is of particular interest as their legislature in 1986 enacted the following anti-dram shop, that's right, anti-dram shop legislation. Louisiana revised statute Title IX, Section 2800.1, limitation of liability for loss connected with sale, serving, or furnishing of alcoholic beverages. Subsection A, the legislature finds and declares that the consumption of intoxicating beverages rather than the sale of serving or furnishing of such beverages is the proximate cause of an injury, including death and property damage inflicted by an intoxicated person upon himself or upon another person. Subsection E is of interest as it still may find liability upon a person who forces or tricks someone into consuming alcohol. Subsection E reads, the limitation of liability provided by this section shall not apply to any person who causes or contributes to the consumption of alcoholic beverages by force or by falsely representing that a beverage contains no alcohol. Now that we've explored the broader context of Dram Shop Acts, let's narrow our focus to the specifics of how these laws are implemented in Texas and Oklahoma. In 1987, Texas adopted its own Dram Shop Act, which is currently codified in Texas Alcoholic Beverage Commission Code, Section 5.01, Civil Liabilities for Serving Beverages, Texas Alcoholic Beverage Commission Cause of Action, Section 2.02. In summary, the Texas Act does not limit causes of action against an, quote, individual whose consumption of an alcoholic beverage allegedly resulted in causing, end quote, personal injury or property damage. The Act provides an additional cause of action for such injured parties against those who provided, sold, or served an alcoholic beverage if it can be proven that, 1, at the time the provision or the serving occurred, it was apparent to the provider that the individual being sold, served, or provided with an alcoholic beverage was obviously intoxicated to the extent that they presented a clear danger to themselves and others. Also, number 2, the intoxication of the recipient of the alcoholic beverage was approximate cause of the damages suffered. So there's a causation element in there as well. Subsection C only places liability on adults 21 years of age or older for damages arising from the intoxication of minors, but this specifies minors under the age of 18 if the adult knowingly A, served or provided the minor any of the alcoholic beverages that contributed to the minor's intoxication, or B, allowed the minor to be served or provided any of the alcoholic beverages that contributed to the minor's intoxication on the premises owned or leased by the adult. Thus in Texas, per subsection C, liability is not placed upon a parent, guardian, or spouse of the minor, nor does it place liability upon an adult to whom the minor has been committed by a court. As we've reviewed, the Texas statute permits liability in specific situations upon those providing, selling, or serving alcoholic beverages. In most cases, employers are accountable for their employees' actions under the doctrine of respondeat superior, which translates in Latin to let the master answer or the master must answer. However, Texas law also offers protections to employers, which in some instances provides an immunity to employers even if their employees provided alcohol to noticeably intoxicated persons. Texas Alcoholic Beverage Commission Code Section 106.14, Actions of Employees, provides in part as follows under subsection A. For purposes of this chapter and any other provision of this code relating to the sale, service, dispensing, or delivery of alcoholic beverages to a person who is not a member of a private club on the club premises, a minor or an intoxicated person, or the consumption of alcoholic beverages by a person who is not a member of a private club on the club premises, a minor or an intoxicated person, the actions of the employee shall not be attributable to the employer if, 1, the employer requires of its employees to attend a commission-approved seller training program, 2, the employee had actually attended such a training program, and 3, the employer has not directly nor indirectly encouraged the employee to violate such law. The Texas Supreme Court has referred to this section as a safe harbor provision for employers, characterizing it as follows. This provision is a carrot that gives providers an incentive to ensure that their employees complete the training the legislature has determined to be beneficial. The third prong of this provision, however, restricts its protections and reflects the legislature's concern that an employer may exploit this protection from liability by encouraging its employees to violate the law, increasing its profits while defeating the statute's purpose. And that was in 20801 Inc. versus Parker in 2008. Many companies with employees who serve alcohol typically possess a solid understanding of these regulations due to permits, which are required to serve alcohol. Additionally, insurance providers aiming to reduce their liability will typically require compliance with the safe harbor provision so that the companies they insure qualify for this immunity. And that is a good thing when it works. However, in instances where these protections fall short, and a company is not following the safe harbor provisions of 106.14, they should not be granted immunity from the actions of their employees. And in those instances, it becomes essential to engage an attorney well-versed in these regulations. Through discovery, such an attorney can attempt to identify inconsistencies that might potentially undermine an employer's legal immunity under this section of the code. We've covered the basic fundamental aspects of Texas's Dram Shop Act, including employer liabilities and available defenses outlined in the statute. It is important to note that the applicability of specific sections can vary depending on the individual circumstances or facts of a particular case, which also will require a review of relevant case law for each potential claim. We will now briefly shift our focus to discuss Oklahoma's Dram Shop Act before concluding. In Oklahoma, things are a little bit more complicated, although they did start out fairly simple because in 1907, Oklahoma passed a Dram Shop Act, which provided in part the following. Every wife, child, parent, guardian, employer, or other person who shall be injured in person or property or by means of support by any intoxicated person or in consequence of intoxication of any person shall have a right of action for all damages actually sustained in his or her own name against any person, individual or corporate, who shall by selling, bartering, giving away, or otherwise furnishing intoxicating liquors, contrary to the provisions of this act, has caused the intoxication of such person. And that was in Title 37, Section 121. That statute appears to be clear, concise, and easy to understand. It encompasses so many parties in its very first sentence that it is meant to encapsulate just about anybody that's harmed by an intoxicated person. One would also have to provide alcohol, quote, contrary to the provisions of this act and have caused intoxication of such person to be potentially held liable. In 1907, the Dram Shop Act that was passed under Title 37, Section 121, went into effect the following year in 1908. It should be noted that at the same time, Oklahoma in 1907 had just been admitted as the 46th state to the United States under President Theodore Roosevelt. The Oklahoma legislature, while passing the Dram Shop Act, also banned liquor. Now note that this was 12 years before the 18th Amendment to the United States Constitution in 1919, which prohibited the manufacture, sale, or transportation of intoxicating liquors. Now, as we've discussed, prohibition at the federal level ended in 1933 with the 21st Amendment to the United States Constitution. However, Oklahoma did not lift their ban on liquor in 1933. It was not until 1959 that Oklahoma even allowed alcohol sales. Also, the restrictions at that time on alcohol, once alcohol sales were allowed, were pretty intense. In fact, serving alcohol in restaurants was still banned and didn't become legal until 1984. But let's focus on 1959 for a moment. When Oklahoma sought to make liquor legal, they passed the Alcohol Beverage Control Act. And in doing so, Oklahoma also repealed Title 37, Section 121. The Dram Shop Act that was initially put into place at statehood was no longer the law in Oklahoma. Without a statutory Dram Shop Act, the old common law rule that providers of alcohol could not be held responsible for the damages caused by intoxicated persons was the presumption. Without a statute, there was not statutory authority to bring such a Dram Shop Act against a provider of alcohol. While there was a provision within the Oklahoma Beverage Control Act of 1959 that prohibited serving intoxicated persons, it did not provide a civil remedy to third parties that were injured. The legal landscape remained unchanged for 27 years, up until 1986, when the Oklahoma Supreme Court delivered its opinion in the case of Briggins versus Velvet Dove Restaurant. In its ruling, the court concluded that the repeal of the Dram Shop Act in 1959 was not a selective, intentional decision by the Oklahoma legislature, as it coincided with the legalization of intoxicating liquors via state referendum. The court asserted that the legislative intent could not be inferred solely from the legislature's lack of action during this period. The court observed that despite the repeal of the Dram Shop Act in 1959, no prior cases had been presented to determine if a, quote, liquor vendor for on-the-premises consumption may be held civilly liable for injuries due to the acts of a noticeably intoxicated patron upon common law principles of negligence, end quote. The court further highlighted that in Oklahoma, the elements of common law negligence are 1. The existence of a duty on part of defendant to protect plaintiff from injury, 2. A violation of that duty, and 3. Injury proximately resulting therefrom. That's in the Brigance opinion citing Sloan versus Owen, which is from 1977. The court recognized that there was a shift among states away from the traditional common law doctrine of non-liability as to commercial providers of alcohol, and reasoned that common law can change with the times and needs of society as follows. We believe the application of the old common law rule of a tavern owner's non-liability in today's automotive society is unrealistic, inconsistent with modern tort theories, and is a complete anachronism within today's society. The automobile is a constant reminder of a changed and changing America. It has made a tremendous impact on every segment of society, including the field of jurisprudence. In the horse and buggy days, the common law may not have been significantly affected by the sale of liquor to an intoxicated person. The common law of non-liability was satisfactory. With today's car of steel and speed, it becomes a lethal weapon in the hands of a drunken imbibler. The frequency of accidents involving drunk drivers are commonplace. Its affliction of bodily injury to an unsuspecting public is also of common knowledge. Under such circumstances, we are compelled to widen the scope of the common law. The court in Brigance cited Title 37, Section 537. The current version is codified in 37A OS 6-101, of which the relevant subsections are as follows. A. No person shall 1. Knowingly sell, deliver, or furnish alcoholic beverages to any person under 21 years of age. 2. Sell, deliver, or knowingly furnish alcoholic beverages to an intoxicated person or to any person who has been adjudged insane or mentally deficient. The court found that a duty derived from statute, particularly Section 537, and from common law, was owed by commercial vendors to, quote, exercise reasonable care in selling or furnishing liquor to persons who by previous intoxication may lack full capacity or self-control to operate a motor vehicle and who may subsequently injure a third party. It should be noted that the court's opinion was only in reference to situations where alcohol was served for on-site consumption, such as a restaurant, bar, or tavern, which was only made legal 2 years prior in 1984. And since its ruling, there hasn't been any legislative intervention nor the passage of a Dram Shop Act by the Oklahoma legislature. Consequently, there are numerous subsequent cases that have emerged interpreting Oklahoma's now common law Dram Shop Act. In 1992, the question of social host liability was presented to the Oklahoma Supreme Court in Kellogg versus Oler. However, the court found that the defendant was not a social host. Thus, social host liability was not addressed. However, it was addressed somewhat later. We will get to that case in a moment. In 1993, the court addressed the case of Tomlinson versus Love's Country Store, Inc., which tragically involved 3 minors who allegedly entered a convenience store, bought alcohol, and then left the store together in a vehicle driven by one of them. The driver was allegedly intoxicated, and upon driving the vehicle, a collision subsequently occurred. A lawsuit was brought against the convenience store by one of the passengers who later died of the injuries he sustained in the collision. The lawsuit was based on Oklahoma's common law Dram Shop Act. The court held that Title 37, Section 537A1 prohibited, quote, knowingly selling, delivering, or furnishing alcoholic beverages to any person under 21 years of age, end quote. A vendor breaches this duty regardless of whether or not the alcohol is provided for on or off premises consumption. The court found that the deceased minor qualifies as a protected innocent third party, which was contemplated in the passage of Section 537. Additionally, the court held that, quote, a jury may conclude that even if the deceased minor had been drinking as a passenger in the motor vehicle, he was an innocent third party subject to negligence defenses, end quote. In 1994, the court decided on a certified question from federal district court that, quote, a commercial vendor is prohibited by statute from selling beer to minors. A commercial vendor's statutory duty not to sell beer to a minor is not limited to on-the-premises consumption. If the minor is injured after consuming beer purchased from the vendor, the minor may have a cause of action against the vendor, end quote. And that was in the Mansfield versus Circle K case in 1994. In 2001, the court refused to extend dram shop liability upon a social host in McGee versus Alexander. The court defined a social host as, quote, one who receives guests, whether friends or associates, in a social or commercial setting in which the host serves or directs the serving of alcohol to guests, end quote. The court in McGee held that charging guests to defray costs of an event does not change one's status from social host to a commercial vendor. Quote, the basis of that distinction is whether the provider sells or intends to make a profit from the sale of alcohol, end quote. Also, liability does not attach when examining negligence per se, as a violation of a permit under Section 247 doesn't apply to a social host, whereas a social host was never required to get a permit in the first place. Thus, negligence per se does not attach. In 2008, the Oklahoma Supreme Court extended liability upon tribes in the case of Biddle versus Baugh, citing the following rule, quote, like any other state licensed commercial vendor, operating a bar and serving alcoholic beverages for consumption on the premises, the tribe is subject to the criminal and civil jurisdiction of the state's courts and may be hailed into court to answer allegations that it furnished alcoholic beverages to a noticeably intoxicated customer. And in 2023, earlier this year, the court issued an opinion in the case of McGee versus El Patio, which described allegations made by the plaintiff that the defendant company, quote, intentionally and negligently overserved McGee, resulting in his death. It is alleged that Welch and other El Patio employees served McGee 12 beers and 5 shots of tequila over the course of 7 hours and then allowed him to drive. The petition further alleges that several servers bet McGee $200 that he would not meet them at a bar in Oklahoma City later that night. Welch and the servers knew McGee was leaving El Patio to drive to Oklahoma City to collect on the bet. McGee reached speeds of 97 miles per hour on his way and collided with the rear end of a tractor trailer on I-40 near El Reno, Oklahoma. He was ejected from the vehicle and pronounced dead at the scene. The Oklahoma Supreme Court reaffirmed its decision in Ohio Casualty Insurance Company, holding that a commercial vendor is not liable to a voluntarily intoxicated adult. Additionally, quote, there may be a duty not to bet an intoxicated person to drive, but that duty is owed to innocent third parties, not the voluntarily intoxicated adult. There is also one sole Oklahoma Uniform Jury Instruction under Chapter 10, Section 10.14, entitled Dram Shop Duty of Care. In conclusion, we've provided an overview of dram shop laws, their historical origins, and changes through the years. States such as Texas have specific statutes determining liability and some protections to parties if certain conditions are met, while other states like Oklahoma rely on common law for such claims, as established by the Oklahoma Supreme Court, leaving certain aspects of liability and questions of whether liability may exist in certain situations unresolved. In the meantime, the Oklahoma legislature has had the option to weigh in, but they have not done so since 1959. Finally, if you or someone you care about has suffered injuries due to the actions or negligence of another party, or if you've been harmed by an intoxicated driver, please do not hesitate to reach out to our office at 832-702-2424. That's 832-702-2424. If you don't contact our office, I strongly recommend that you seek legal advice from a licensed attorney, and if you already have an attorney, please work with their office. And it is my sincere hope that you succeed in your claim. My name is Chris Sloan with RealDamages.com. Thank you for watching.